Hello and welcome to this presentation on all you need to know about prenuptials and the Radmacher judgment handed down by the Supreme Court. My name is Neil Denny and I'm a collaborative family lawyer with Moj's Solicitors in Bath. Are prenuptials legal? This is the key question that we have to consider when we are advising our clients, whether that's me in my role as a divorce lawyer advising clients at the outset of the marriage, or you in your role as an IFA or wealth manager or other financial advisor. I think it's easy for the press to slip into shorthand references to prenuptial agreements being legal or binding, and what I want to show you over this 10-minute presentation is that this is dangerous, it's overly simplified, and we need to be a bit more aware of just what the Radmacher judgment has said about prenuptial agreements. In a nutshell, prenuptial agreements can now be binding, but they are not automatically so. That means, if you like, that the prenuptial agreement in itself has nothing of a binding nature. So long as both parties agree to continue to be bound by it, then there isn't a problem. But that binding nature comes about only by the parties' ongoing shared consent. When a marriage comes to an end, if one party at that time wants to set aside the prenuptial agreement, that is when we need to go to the court, and we need to ask the court to see whether they will agree not necessarily to be bound by the prenuptial agreement, but whether they will agree to honour it and to uphold what was previously agreed. The court, importantly, has a discretion in deciding that, and that discretion is determined, as it always has been, by Section 25 of the Matrimonial Causes Act. If need be, after this presentation, you can go and have a look at Section 25 of the Matrimonial Causes Act and see what criteria are contained within that. The Radmacher judgment, in addition to that Section 25 criteria, also suggests that there's a three-headed test that needs to be passed. So, if a prenuptial agreement is going to be upheld by the court, there are three criteria that need to be met. First of all, was there anything happening at the time that the agreement was entered into that might make this agreement less binding on the court? Secondly, was there anything going on or anything in the parties' anticipation and understanding which might make the agreement more binding? And finally, do the current situations, so that is to say, do the situations now at the end of the marriage mean that it is still fair to uphold that earlier prenuptial agreement? If you want to drill down with me in this material, then you can get the judgment from this link. The area of the judgment that I'm going to be looking at, bear in mind that the judgment's a full 69 or 70 pages long, the area that I'm going to be discussing here comes from paragraph 67 through to 83, and I think that's the most pertinent part of the judgment. The starting point is this, that the English courts should accord respect to a couple's ability to reach an agreement. They should not be paternalistic or patronising and override prenuptial agreements too quickly. And those are comments which are taken straight from the Radmacher judgment. So, the first of those three heads, was there anything going on that undermines the agreement? Well, the parties should have both entered into the prenuptial agreement by free will, and that's on both sides. Both parties should be informed of the implications of entering into that agreement, at the time, of course, that they entered into it. The judgment makes the point, not surprisingly, that sound legal advice is desirable when entering into prenuptial agreements. This first head of the test goes on. Each party should have had all of the information that is material to him or her making the decision to enter into the prenuptial agreement. So that means that there needs to be disclosure, and that disclosure needs to be full and material. Now, if there has been non-disclosure of a point which doesn't have an impact on the decision to enter into the prenuptial agreement, then that might not completely undermine the prenuptial agreement. So if there has been non-disclosure, but it wouldn't have made a difference to the decision made to enter into the prenuptial agreement, then that might not be problematic. But why take the risk? Both parties should have intended, at the time of entering into the agreement, that their prenuptial would govern the financial consequences of the marriage should it come to an end. Finally, on this head, we have to make sure that there was no duress, fraud or misrepresentation at the time of entering into the agreement, and we also have to make sure that neither party was placed on undue pressure, or that either party was exploiting a dominant position over the other. And again, legal advice at the outset when entering into the prenuptial agreement can help in making sure that all of these, if you like, criteria are met and satisfied. There's a paragraph here that I just want to share with you. This is paragraph 72, and this shows that the range of things that the court would take into consideration in this first head is really very broad. What were the parties' emotional state? What pressures were they under to reach an agreement? All of these issues. Is this their first marriage, or is it a later marriage? Have they got adult children? Have they got assets that they're bringing into the marriage? So you see that the court's consideration is very broad indeed. And although I can try to break all of these down into a bullet point, it's much more nuanced. It's much more delicate than that. The court's consideration is very broad indeed. This means that we cannot advise our clients that a prenuptial agreement is binding at the time that it is signed. It still needs the approval of the court and the marriage comes to an end. So, was there anything going on at the time of entering into the agreement that strengthens the agreement, and how influential it will be on the court? The judgment here gets in a bit of a fumble because it raises this head and then says that it doesn't apply in this current case. But the point that the court is making is that if the couple had a sincere belief that the agreement that they are entering into was going to be binding upon them, then that may well make it more likely that the courts will agree to follow what has already been agreed. So, for example, if there's a foreign jurisdiction, if the couple had believed that a foreign court that they were going to be subject to would approve the prenuptial agreement, then our courts may well find that to be an influential factor in agreeing to uphold that prenuptial agreement. Fairness. The key consideration is this. Is there anything in the parties' current circumstances that would make it unfair to hold them to their agreement? And here's the quote from the judgment itself. The court should give effect to a nuptial agreement that is freely entered into by each party with a full appreciation of its implications, unless, in the circumstances prevailing, it would not be fair to hold the parties to their agreement. So there is always this potential that if the circumstances for the parties have changed between the time that they agreed to the prenuptial and the time that they are coming to the court asking them to set aside or to uphold the prenuptial, then the court has the freedom and the discretion to waive the prenuptial. So, fairness, look at the children. A pre- or post-nuptial agreement cannot be allowed to prejudice the reasonable requirements of any children of the family. There's this point about autonomy, and you'll see this is where I got my earlier quote from. It would be paternalistic and patronising for the courts to override a couple's agreement simply on the basis that the court knows best. Now this is where we need to be careful also. If one party enters into a bad deal, then the court is not necessarily going to rescue them from that. So even though the court might see that this is a bad deal, even though the court may be able to see that there is trouble ahead, the court is not necessarily going to use that as a reason for overruling a prenuptial agreement. The difference between prenuptial agreements and separation agreements, which are agreements made about dividing the assets but within the marriage, is that prenuptial agreements inevitably deal with future events, future unknown events. Prenuptial agreements are often made with no real anticipation of future events, and that can undermine the court's willingness to uphold an agreement. So, if future events are anticipated and catered for within the drafting of the prenuptial agreement, then that will make it harder for a court to override an agreement. This is another good reason to make sure that prenuptial agreements are properly and carefully drafted at the outset. If there are unaddressed changes in circumstances, then again that can lead to an agreement not being upheld by the court. So that means that prenuptial agreements shouldn't just be completed and then filed away in a storage room in a safe and just forgotten about, but rather they should be reviewed regularly. Certainly upon changes in circumstances, the birth of a child for example, a serious illness, receiving a large inheritance or other windfall, those kind of circumstances. Quick paragraph here, which I think really flags up the danger in assuming that prenuptial agreements will be binding. The parties are unlikely to have intended that their antenuptial, their prenuptial agreement should result in the event of the marriage breaking up in one partner being left in a predicament of real need, while the other enjoys a sufficiency or more. Such a result is likely to render it unfair to hold the parties to their agreement. Now, I think this is an important safeguard. What it says is, do not think that you can enter into a prenuptial agreement which will just leave your future spouse high and dry in the event of the marriage coming to an end. Now, of course, prenuptials are designed to protect assets, but we cannot simply cut one party off at the end of a marriage by trying to use a prenuptial. Back to this quote, equally, if the devotion of one partner to looking after the family and the home has left the other free to accumulate wealth, it is likely to be unfair to hold the parties to an agreement that entitles the latter to retain all that he or she has earned. So this is the court saying once again that if one spouse is playing a traditional homemaker role, looking after the children, looking after the home, leaving the other spouse free to go out, develop their career and to accumulate wealth to take from the judgment, then the court is going to be slow to uphold an agreement which doesn't allow for some redistribution of that accumulated wealth. So to summarize, and I'll just wrap up here, prenuptial agreements themselves are not automatically binding. If they are disputed when the marriage comes to an end, then the court will apply this three-headed test to see whether they should be approved and upheld. Fairness seems to be the trump card, and that is quickly followed by need. Needless to say, what should we advise our clients? You should ensure that they take independent legal advice, and I would add here that that advice should be taken from a specialist family lawyer. It should be taken in a timely fashion, so not immediately before the marriage. All relevant and material disclosure should be exchanged between the parties. And records should be kept not only of that disclosure, but also of the parties' intention and their emotional state, perhaps a record of their reasons for entering into a prenuptial agreement. There should be reminders diarised to review the prenuptial agreement upon change of circumstance or periodically. I hope that this presentation has been helpful to you. If you've got any more questions, then please do not hesitate to contact me. My telephone number is 01225 750079. You can contact me via the website at www.mojers.co.uk, or you can email me neildenny@mojers.co.uk. If you like and if you use Twitter, then why not follow me and let me have a comment on twitter.com/MojersLaw. Thank you.